had to have been installed by someone who is physically present at Mr. Duggar's computer on May 13th, 2019. There was no evidence that Mr. Williams was present on Mr. Duggar's car lot or even in the state of Arkansas on that date. He was outside Arkansas between May 11th and May 16th, and the government proffered that it had receipts, videos, and, if necessary, live testimony from multiple witnesses confirming that Mr. Williams was outside Arkansas for that entire period.
Hey everyone, it's Katie from Without a Crystal Ball. Welcome back to my channel. It's Thursday, February 16th, 2023. It's the day for Josh Duggar. While he is sitting in a cell by himself because of a phone that he brought into Seagaville, his attorneys were up in Kansas City arguing for a new trial. Now, if you're wondering if Josh having a phone inside Seagaville came up at the appeals hearing today, it did not. But the case was heard by the judges in the 8th District, and Josh's attorney, Justin Gelfand, did the arguing for his side, and the U.S. prosecutors, the U.S. attorneys, were on hand for their side of the arguments. The whole appeals process, the oral arguments, was just under 40 minutes long, and it's hard to tell what they're going to do here, but it seemed like, as I was listening to all of this, that they had a lot more questions for Josh than they did for Josh's defense attorney than they did for the U.S. attorneys, which seems to me there were a lot more holes in the arguments that Justin Gelfand was making to the appeals court. And if you're interested or curious to hear Justin Gelfand talk, there's something about his voice. I can't put my finger on it. But I'll be posting this full audio, and I'll be interjecting in between with some reactions that I have or some insight that might help you understand what it is that they're talking about. So before we dive into today's topic, please do me a favor and give this video a thumbs up. Also, please subscribe to my channel if you've not yet subscribed by turning the notifications on so you know when I go live or when new content loads, as well as make sure to leave a comment if you have something to say and share this video with your friends. So we will start from the beginning where Justin Gelfand starts introducing the case. Check this out.
This court should reverse the conviction below for 3 reasons. First, the district court applied a test the U.S. Supreme Court has already determined is unconstitutional in denying Mr. Duggar the opportunity to present a complete defense. Second, Mr. Duggar was interrogated outside the presence of his attorney after law enforcement had physically taken his phone from his hand when he was attempting to contact his counsel. And third, the district court erroneously introduced expert testimony as lay testimony as to a critical issue in the case, EXIF metadata, and making matters even more egregious, the district court denied the defense computer forensic expert, Michelle Bush, the opportunity to critique the methodology that the government's expert witness, Mr. Fotrell, utilized. The first issue, the opportunity to present a complete defense.
I never knew what Justin Gelfand sounded like until this audio. And I mean, I guess I saw some brief interviews, but to actually hear him arguing in court, there's something about the way that he argues where it seems like very dramatic, like he's acting like what happened to Josh is so horrible. And I don't know if this is standard. I'm sure defense attorneys are known to put on the dramatics in court, but I just kind of got the sense that it's like he was like, it was egregious. Like, I'm trying to imagine an egregious situation that involves Josh Duggar that isn't part of what he did. You know what I mean? Like, was this really egregious, or was Josh's conduct what was actually egregious? It's just, those were my first initial reactions.
At trial, the defense attempted to elicit testimony from a witness who was under subpoena and physically outside of the courtroom available to testify, Caleb Williams. Caleb Williams, for context, had worked at Wholesale Motor Cars, which was the scene of the alleged crime. Caleb Williams was listed on a sales contract as the salesperson approximately 6 weeks earlier. He regularly used the only computer at issue, the HP PC computer, for purposes that had nothing to do with Wholesale Motor Cars or Josh Duggar. He used it to print shipping labels for eBay sales personally. He texted Mr. Duggar on May 7th, approximately a week before the alleged crimes, offering to, quote, watch the lot the following week. He spent the night 1 mile away from the lot, at a car lot, by the way, 2 days later on May 9th of 2019. He took a photo of Mr. Duggar in the office where the alleged crime occurred, of Mr. Duggar using a MacBook laptop in the car lot office, not the HP computer at issue, and he concealed all metadata in the documents that he provided to the government when investigators finally, at the 11th hour just before trial, did any investigation as to him.
My understanding is, though, the district court didn't preclude you or your client from calling Mr. Williams. It was just a threshold showing of a nexus between, I guess, a time and a place nexus. Is that correct?
No, Your Honor. What the district court did is the district court expressly said that we could call Mr. Williams for a very limited purpose. We could ask him whether he had knowledge or recollection of being present on the lot between May 13th and May 16th, and whether he remoted in. But what the district court next said is critical, and this is on page 1364 of volume 6 of the transcript. He said if he says he wasn't there and didn't remote in other words, if he denies committing the crime for which Mr. Duggar was on trial, quote, that's as far as you're going to get. And he further explained that he would not permit impeachment based on Mr. Williams's prior felony conviction.
Isn't that exactly what Judge Kobus just asked you, that there was an insufficient nexus unless he admitted on the stand that he was actually there or had remoted in or had some connection to that computer?
Your Honor, I don't believe so, and I'll tell you the reason why. The day before this sidebar at trial happened, there was a critical on-the-record in-chambers conference on this exact issue that sheds light into the test that the district court actually applied. And it was not the insufficient nexus test that applies in the 10th Circuit and that has never been adopted by this court. But putting that legal issue aside...
What's the test that should have been used under 8th Circuit precedent?
The test that should have been used is the test that applied in the Holmes case, which is that you have an absolute constitutional right to present evidence of an alternative perpetrator. That's what the U.S. Supreme Court said. That's binding precedent in this court. But to answer the court's question, Judge Strauss, what the court said, and this is on pages 910 and 911 of Volume 5, this is that day before hearing, was critical. The court said this concept that the greater the strength of the evidence, in other words, the government's evidence and the court's view on that, quote, that weighs into part of the court's analysis as to whether it will include or permit or exclude that, end quote. And so what the court was saying a day before trial is essentially that the court was looking at this through the lens of if the court believes the strength of the government's case is greater, then that decreases the relevance or the appropriateness of admitting this alternative perpetrator testimony. But that's an unconstitutional test. And then the very next day...
Why isn't the court simply requiring an appropriate foundation, appropriate evidence for a foundation for testimony that you would have liked to have solicited?
Precisely because the court articulated the test that was invalidated in Holmes as the test that the court was applying. And that's the significant distinction here, and that's the distinction with a difference. This was not a foundation issue, and by the way, as we briefed, there was unambiguously a sufficient nexus if this court were to hypothetically adopt the 10th Circuit's rationale.
But that goes only to some of the testimony, because my read of the record is, at least with respect to the prior conviction, the district court was quite clear in doing a Rule 403 balancing. And I basically said that it'd create confusion for the jury, sort of a mini trial, et cetera. And so maybe you have a different view, but I don't think that goes to the prior conviction at all.
Your Honor, I think it goes to the prior conviction insofar as the court was considering at that sidebar and at the at the Chambers conference the day before, the issues combined. Because what the court essentially said was, you can call Caleb Williams and you can ask him under oath, did you commit the crime? And if he says no, you're done. No lawyer in their right mind is going to call a witness to say that and then have to sit down without the ability to impeach that
what was the evidence that you wanted to get in?
The evidence that linked Mr. Williams as an alternative perpetrator, specifically that he places himself regularly, and the evidence places him regularly at the car lot or near the car lot, using the computer that was the only computer, despite many electronic devices and computers being seized, that had alleged that Mr. Williams specifically texted Mr. Duggar on May 7th, and we wanted to authenticate that text through Mr. Williams, offering to, quote, watch the lot, end quote, during the time period, or at least very close in time to the time period that this crime occurred. And at that point, the district court effectively deprived Mr. Duggar of that ability. It was not our burden, it would be burden shifting, to prove that Mr. Williams committed any crime.
So was the takeaway of the evidence that you wanted to get admitted, basically, that he had access to the computer?
What we wanted to get admitted was that he had access to the computer, familiarity with the computer, access to the car lot, and that the government failed to prove Mr. Duggar guilty beyond a reasonable doubt by failing to rule out Mr. Williams as an alternative perpetrator. And it's a reasonable doubt analysis that's key. The burden always remains on the prosecution, here and everywhere. That's not only what the law allows, but what the Constitution requires. And that's what the Supreme Court emphasized in the Holmes case. And that's what's so troubling about what's clear in the record here. There's no ambiguity about what the court did. The court articulated the test both the day before and at sidebar that the court was applying. And that's critical. There's, bear in mind, no response from the government in its briefing as to this conference the day before. And that's what sheds significant light, by the court's own words, as to how the court was approaching this precise issue. That requires reversal under Holmes.
I wanted to make sure that you had the whole opportunity to listen to that without me interrupting. But I just wanted to sort of point out a few things that I noticed, and that any time that he spoke, Justin Gelfand argued about any sort of crime being committed, he always referred to it as an allegation when it came to Josh. So it was an alleged crime. But when he was talking about Caleb Williams, he never used the word alleged crime. He would say when the crime was committed. So it's like this weird play of words, like he still will not admit that there was even a crime that committed if it was associated with Josh. So he's being very calculated in how he uses his phrasing there, and then he's placing the crime with Caleb by calling it a crime when he talks about Caleb. The other thing that I noticed was that he flat out said, it's not our burden to prove that Caleb did this. That's the burden of the prosecution. And that tells me is that they know that he's probably not the person that did this, but it's someone that they can introduce to the jury that he believed would make them think that he was an alternative perpetrator. The problem is that the prosecution had evidence that proved that he wasn't there on those days, that they actually presented in chambers that showed without a reasonable doubt that Caleb was not physically at the car lot, was not there to download any of the content, and couldn't have done what happened. And the only person that was there on the days that things were actually downloaded was Josh. So a lot of his arguments I would classify as sort of a red herring, where they're just picking out a small detail that is really irrelevant to the overall scope. Ultimately, he wasn't denied the right to call Caleb Williams, and if you notice, there was a lot of questions from the judges. And when we listen to the prosecution side or the U.S. attorney side, you'll also notice that there's not as many questions to them for their arguments.
The second issue is that of suppression. And in this particular instance, federal agents made a beeline after doing surveillance, waiting for Josh Duggar to appear at Wholesale Motor Cars to execute a search warrant. They swarm in 6 law enforcement vehicles. They're wearing ballistic vests and they're armed. And they make a beeline, 2 of them, directly towards Mr. Duggar. At that point, he takes out his phone, physically puts it to his ear, and there's no factual dispute in the record below and in the trial court below, both at the suppression hearing and the trial testimony, that Mr. Duggar lifted his phone to his ear for the precise purpose of contacting his legal counsel. What federal agents did is they physically took the phone out of his hand, and from that point forward, deprived him of the ability to communicate with his legal counsel, as was his constitutional right.
Was there a phone on the premises? Any other phone on
There's
the premises?
no evidence at all in the record of phones that were either not seized. There were other phones, Your Honor, that were seized by law enforcement, for example, from other people that were present at the car lot.
Was there any statement by the officers that he could not make contact with them or that was prohibited?
There was no express statement, Your Honor, I don't believe. However, there was no physical mechanism for him to contact
He
counsel.
was told he was free to go, is that correct?
The testimony at the trial below and at the suppression hearing was that he was told he was free to go, but no, that's not the test. No reasonable person sitting in his shoes at that time would believe that their freedom of movement was not.
Did he seek to go to an adjacent business or someplace else to make a phone call?
No, Your Honor, and the reason why, and this is undisputed in the record, is that as the court found as a factual finding, obviously subject to significant deference by this court, is that this lot was accessible only by a 4-lane divided highway with no sidewalk. It was, quote, in the middle of nowhere, end quote. That's the district court's finding. And what's critical about that is there was nowhere to go. So the notion that, you know, if what is essentially being pictured is this, you know, car lot in like a car mall, if you will, that's the exact opposite of what this was. This is a used car lot in the middle of nowhere that's literally accessible with a highway with no sidewalk. He had no phone.
Did he explicitly invoke his right to counsel, though, and say, hey, I want to call counsel. I don't want to answer any questions?
Your Honor, I believe he did explicitly invoke his right to counsel, and it was undisputed that that's what the agent understood his attempt to do. I actually think it's, if there is a such thing, Your Honor, it's more than actually invoking the right to counsel when you physically try to contact counsel, and when law enforcement literally prevents you from doing so by interfering with the mechanism that you're using to contact counsel. That's one step even greater than some of the court's prior jurisprudence of, you know, is it a clear invocation? You know, was it? Maybe I should talk to a lawyer, maybe I shouldn't. This was literally an attempt. I'm calling my lawyer, and the agent saying, no, you're not, and physically taking the object from his hand.
You don't contest the fact that the warrant authorized the officers to seize the phone.
No, Your Honor.
So your suggestion is here, the Constitution will require them to wait until he finishes phone call and then seize it?
No, Your Honor, the Constitution does not require them to wait and to seize it, but the Constitution, after the invocation of counsel, requires them not to interrogate him until his lawyer is physically present. So the issue is not about the seizure of the phone.
But there wasn't where is in the record is there an actual invocation of the right to counsel?
When the special agent who testified at the suppression hearing expressly admitted in no uncertain terms that Mr. Duggar was taking his phone out and articulated that he was calling his lawyer. I believe that's as clear an invocation of the right to counsel as you could possibly have. I am calling my lawyer. That's an invocation of the right to counsel. That's not vague. And it wasn't misunderstood by the agent either. The agent, to his credit, admitted that under oath at the suppression hearing.
Do you have presidential authority for that act being clear statement of invocation?
No, Your Honor, and one of the things that's really interesting here is that of all of the cases involving the invocation of the right to counsel and the issues that are before this court, this is the only case that I could find, there may be other cases out there, but it's the only case that I could find where an individual was physically in the act of contacting counsel and was physically stopped by law enforcement from doing so. That's a unique fact pattern. That's a unique situation. It's not surprising that that doesn't happen or hasn't happened historically, at least to the extent of further litigation.
But did Mr. Duggar state to the police officers, I want my attorney before I will talk to you? This is...
In those words, no, Your Honor, but I believe by stating I'm calling my lawyer and physically doing it, that's a clear invocation of the right to counsel. I don't think there was any ambiguity. And to the agent's credit, no one has suggested at all at the trial court below, at suppression, or at any point that this was an ambiguous invocation of the right to counsel.
But all of this, in terms of the suppression, depends on him being in custody under our Griffin factors. And what's the best, in your view, other than the fact that it's remote and other than the fact they came in with these ballistic vests, what's your best argument that he's in custody despite the fact they told him he wasn't in custody?
Your Honor, under what the Griffin court says is non-exhaustive Griffin factors, but the factors that have been used, as the court pointed out, for approximately 30 years, plus or minus. The best arguments that he was in custody is this context under Miranda's version of custody. Would a reasonable person believe that he's free to leave?
Did he have a vehicle to depart in?
No, Your Honor. The vehicle that he came in was seized, it wasn't seized, it was searched, and so he had no access to it. And all the keys to the other vehicles at the car lot were in the office where law enforcement was physically at. And there's actually testimony that he wouldn't have been allowed to enter any of those buildings without an escort. That's on page 31 of the suppression hearing. And so what's significant here, Your Honor, is that these agents are wearing ballistic vests, they're armed. The circumstance is such that when he invokes, or at least what we believe is invokes, his right to counsel, they're coming at him, making a beeline towards him, and physically stopping him from contacting his attorney. That's what no reasonable person would sit there and say, police regularly grab my hand. That's kind of analogous to what someone would think if your hands are grabbed, that you are being placed under arrest. And in that instance, I think that under Griffin, which of course is a case-specific analysis here on de novo review, that what this court should find is that he was actually in custody. If I may reserve the remainder of my time for rebuttal.
When it comes to the issue of his phone, his attorney, Justin, seems to be playing games of trying to confuse attorneys, as well as, again, more red herring, because he focuses a lot of his argument on the seizure of his phone. But at one point, even in his own, when a judge asked him a question about the phone, he said it isn't actually the issue of the seizure of the phone. It's the issue that he was in custody. So he's making a lot of arguments about how it was so, Josh was so scared and these poor men were trying to take his phone and then at the same time going, well, it's actually not the issue. The issue isn't that they took his phone. It's the issue that he said he wanted to talk to an attorney and he wasn't allowed to talk to an attorney because he was in custody. And then when asked if he was in custody, because that is the burden they have to overcome, and this is what the judge in the lower court already ruled, was that he wasn't in custody because he was free to leave. He wasn't arrested. He wasn't restricted from movement. He had the ability to use anyone else's phone. He was not ever placed into handcuffs. The phone was actually a part of the search warrant, which you heard the judge ask him about the phone and saying, so were they not supposed to take the phone? That was part of a search warrant. And he said, well, no. And he said, and then wait for him to be done making the call and then take the phone. And then he said, well, no. So really, this whole argument about the phone is just one big red herring, because ultimately taking the phone doesn't change the fact that he could have called anyone at any time, not to mention he wasn't under arrest. And so when it comes to custodial interrogations, you're only allowed for a Miranda, and you're only allowed for once an attorney is invoked, you have to be in custody. He wasn't in custody. So that's why they keep talking about, well, was he in custody? Because once in custody, if someone evokes right to counsel, they cannot be questioned any further. He was not in custody, so therefore a presumptive, I'm going to be arrested, I want to speak to an attorney, wouldn't qualify. Nor could Justin point to any point at all where he flat out said, I want to speak to an attorney about this, or indicating that he knew he was under arrest. There was nothing. And then when he asked them, did you have any court of law, is there anything in these courts that you can argue to show us that him saying he was calling his attorney is for us to assume that that's what he meant and that he was invoking his rights, because it's not invoking his rights. And Justin didn't have an answer. Ultimately, it's much to do about nothing. I don't see him at all getting this overturned. There will be a few questions when the U.S. attorneys come up, and I'll let you hear their side now.
Good morning, Your Honors, and may it please the Court, Josh Handel for the United States. I'll begin with the alternative perpetrator evidence and the Caleb Williams issue. So there was no error in the district court's ruling on the hypothetical testimony of Caleb Williams. I think it's helpful to remember at the outset what the undisputed lay of the land is here. Everyone agreed at trial that the partitioned section of Mr. Duggar's computer, which was the part of the computer containing all of the child evidence was recovered, had to have been installed by someone who is physically present at Mr. Duggar's computer on May 13th, 2019. There was no evidence that Mr. Williams was present on Mr. Duggar's car lot or even in the state of Arkansas on that date. To the contrary,
The partition section, to refresh my recollection, was that generally available to anyone using the computer, or was it protected in some way?
No, Your Honor, it was password protected by the password Intel 1988 that Mr. Duggar had used for years across a number of accounts. Yes. To the contrary, there was abundant evidence. All the available evidence indicated that Mr. Williams was not present in Arkansas on that date or any other date relevant to the conduct here. Mr. Williams told, I believe, both sides' investigators that he was not there on that date. He was outside Arkansas between May 11th and May 16th, and the government proffered that it had receipts, videos, and, if necessary, live testimony from multiple witnesses confirming that Mr. Williams was outside Arkansas for that entire period. Now, notwithstanding that uncontroverted evidence placing Mr. Williams elsewhere, the district court did give Mr. Duggar a wide berth to elicit relevant testimony. The court told Mr. Duggar that he could call Mr. Williams to the stand. Upon doing so, Mr. Duggar would have been allowed to ask Mr. Williams about any fact to which Mr. Williams was a percipient witness, including Mr. Williams's dates of employment at the car lot, his prior experience with the computer, his contacts and text messages with Mr. Duggar. I believe at record document 156, page 21, the district court goes through all of the different aspects that Mr. Duggar would have been permitted to ask Mr. Williams about if he had called him to the stand. He also would have been permitted to lay a factual foundation for Mr. Williams's personal knowledge of or involvement in the relevant conduct, including by asking whether Mr. Williams was present at the car lot between May 13th and 16th, and whether he had ever remotely accessed Mr. Duggar's computer. The sole limitation that the district court imposed was that if Mr. Williams testified that he was not present between May 13th and 16th, and that he had never remotely accessed Mr. Duggar's computer, the defense would not then be allowed to impugn Mr. Williams as an alternative perpetrator based solely on his unrelated prior sex offense. That limitation was consistent with at least 4 lines of authority. Number 1, with Federal Rule of Evidence 602, which limits admissible testimony to only those matters where, quote, evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Here, there was no evidentiary foundation for Mr. Williams's presence at the car lot or remote access to the computer on the relevant dates, except that which Mr. Williams might provide through his own testimony. The district court appropriately permitted Mr. Duggar to try to lay such a foundation through Mr. Williams's testimony, but it made clear that if Mr. Williams testified in such a way that did not lay a foundation for his presence or his access, then there would be no basis to continue with that line of questioning. The court's limitation was also consistent with its gatekeeping role under Federal Rule of Evidence 403, which permits the district court to exclude even relevant evidence that would create unfair prejudice, confuse the issues, or mislead the jury. Here, the district court correctly determined that the introduction of Mr. Williams's prior conviction would have little probative value, but would very likely mislead the jury and create a risk of unfair prejudice. And that's especially the case because that conviction carries no obvious value as impeachment evidence in these circumstances. It is not an offense involving a dishonest act or false statement. It does not place Mr. Williams in proximity to Mr. Duggar's computer on any relevant date, and it does not suggest his technical capacity to have installed the partition or remotely accessed the computer. The court's limitation was also consistent with the Supreme Court's decision in Holmes versus South Carolina. Now, I believe my friend on the other side suggested that Holmes set down the principle that defendants have an absolute constitutional right to introduce alternative perpetrator evidence. In fact, Holmes expressly approved the principle that alternative perpetrator evidence, quote, may be excluded where it does not sufficiently connect the other person to the crime, as, for example, where the evidence is speculative or remote, end quote.
Counsel, I'll tell you exactly what concerns me. The district court made an error of law in one respect. The district court said the critical inquiry concerns the strength of the prosecution's case. And when I was reading the materials in this case, my eyes just about bugged out of my head, because I'm like, that is clearly wrong. It's not the case that a stronger prosecution case means you can exclude alternative perpetrator evidence. So what I'm trying to figure out is, did that infect the rest of the district court's analysis on alternative perpetrator?
Absolutely, Your Honor. So a couple of points on that. We acknowledged in our brief, as did the district court below, that during one of the times that this was addressed at trial, the district court inadvertently read the wrong passage from Holmes into the record. I would point out that the district court stated the correct principle the day before when it said, quote, there has to be some demonstrable nexus of proof that links the alternative perpetrator to the crime, end quote. The district court, the Supreme Court in Holmes also never said that you cannot consider the strength of the prosecution's evidence. It just says that you can't solely consider the strength of the prosecution's case. Obviously, the strength of the prosecution's case is in some respects relevant to the probative versus prejudicial balancing test that Rule 403 instructs district courts to engage in. But just to kind of allay your concerns about the one instance where the district court read the wrong passage of Holmes, the court also contemporaneously, right in the same section of transcript, contemporaneously quoted decisions applying the correct principle. And this is at the trial transcript, volume 6, page 1362, where the district court describes as the, quote, money quote, the Tenth Circuit's holding that a non-speculative nexus between the crime charged and the alleged perpetrator is a threshold requirement for alternative perpetrator evidence. And finally, the district court explained post-trial that its misstatement was inadvertent and did not reflect a misunderstanding of the applicable principle. That's at record document 156, pages 19 through 20. I don't believe Mr. Duggar has ever expressly contended that the district court was misrepresenting its recollection or its understanding of the law. We certainly see no basis in the record for making that kind of conclusion.
So Josh Handel, the U.S. attorney that's arguing on the appellate side, this is an attorney that literally his job with the U.S. attorney's office is to be on these appellate cases, is pretty clear that there was evidence to show that Caleb Williams was not there. There was a lot of clear reasons Josh could call Caleb. There was a lot of questions Josh could ask Caleb. Despite all of that, he did not call Caleb Williams. There's a lot of arguments by Justin that, Caleb was eliminated or could not be called because if he didn't say he was there, then he would go off the witness stand. And obviously, as Joshua was explaining, is that there just wasn't any evidence that he was there. And they very rarely at all, truly, ever, at all, interrupted. There was only one question or a couple questions. One was about, a misreading of a law, which the U.S. Attorney Joshua Handel cleared up and said that it wasn't factored as a reason for why the court didn't made the decisions that it did. But there was also nothing connecting Caleb to the actual dates that this happened. That wasn't more than speculation. And because there was no direct evidence that he was there, it would create confusion for the jury, because the reason why they want to call Caleb is because he has that conviction in an unrelated situation, not like what Josh did. And it would confuse them and prejudice Caleb and prejudice the jury, because they'll be like, oh, well, this guy has this conviction. But if he wasn't there, it's irrelevant that he has the conviction because he wasn't there. So their argument is that the judge made the right choices and that Caleb could have been called, but they chose not to. And Gelfand said, well, what attorney was going to call him under those circumstances? When I listened to the U.S. attorney's argument versus Justin Gelfand's and how the judges responded, there was a lot less questions to Handel's arguments than there were to Gelfand's, which tells me that Handel's arguments were a lot more solid and based in fact versus the red herrings that, again, Justin Gelfand likes to use.
So the district court correctly declined to suppress Mr. Duggar's voluntary statements to Agents Faulkner and Aycock because Mr. Duggar was not in custody at any point during the search of his used car lot. For over 30 years, this court has considered the same 6 Griffin factors to decide whether an interview was custodial. On pages 24 through 30 of our brief, we went through all of those factors and explained why each supports the district court's finding that Mr. Duggar was not in custody. I want to focus on just 2 that I think are particularly salient to the analysis in this case. So number 1, Mr. Duggar was repeatedly told that he was not in custody and was free to leave.
Of course, the incantation of that, or statement of that incantation, you're free to go, is not by itself always sufficient if there are other circumstances that indicate a person really isn't free.
That's true, Your Honor. I agree that those are not magic words that, could otherwise excuse extremely egregious custodial circumstances or something like that. I would note, however, that in the Zacray case, which we cite in our brief, you said that, quote, no governing precedent of the Supreme Court or this court holds that a person was in custody after being clearly advised of his freedom to leave or terminate questioning. So if they aren't magic words, they're about as close as we can come under the prevailing precedent. But here, I think it's important that the agents didn't just kind of say this as a general prophylactic and leave it at that. Mr. Duggar was advised meaningfully on at least 3 separate occasions that he was not under arrest and was free to leave. First, when the agents approached him and informed him that they were there to execute a search warrant rather than an arrest warrant, and he was free to leave. He even engaged in a little bit of back and forth with them, explained to the agents that his wife was pregnant and was expecting soon, and that he may have to leave in order to contact her, and the agents said, that's perfectly fine. Second, when Mr. Duggar was presented with the statement of rights forms at the outset of his conversation with the agents, and the agents, in fact, manually edited that form at Mr. Duggar's request to remove the phrase into custody, which is kind of the standard language that they put on that form. Mr. Duggar was somewhat bothered by the phrase into custody, and so they said, all right, we'll edit that, we'll cross that out. And finally, when Mr. Duggar indicated to the agents that he would, quote, leave here sooner rather than later, and they again reiterated that it was his decision whether and when to leave the scene. And that brings us to the second of the Griffin factors that I think is especially relevant to this case, which is that Mr. Duggar did leave the scene of his own volition at a time of his choosing and without being arrested. This court has considered circumstances that are candidly much closer to the custodial line, but found no custodial interrogation where the interaction terminated without an arrest. So in the Mullenbrook case that we cited at page 30 of our brief, the suspect was transported in a police car from his home to the station and questioned in a small windowless interrogation room behind closed doors. And this court determined that that was not a custodial interrogation because at the end of the interrogation, the police drove him back home and he was not arrested. Here, Mr. Duggar voluntarily ended the interview. He left his employee, Randall Berry, in charge of the lot for the rest of the search, and he departed under his own power. He was, in fact, not arrested until almost a year and a half later. So I think those 2 factors, as we pointed out in our brief, we think that all 6 of the Griffin factors favor the government here and clearly foreclose any contention that Mr. Duggar was in custody, but certainly the fact that he was repeatedly advised that he was not in custody, repeatedly advised that he was free to leave at any time, and that he then availed himself of that liberty and left the lot at a time of his choosing without needing the officers to drive him, without even needing them to move their cars, without needing any assistance from the officers. I think that clearly forecloses any contention that this was a custodial interrogation.
I am a little concerned, though. I mean, I get the point on custody. I asked opposing counsel about it, but I'm a little concerned when you know apparently the agent knew that he was trying to call his counsel, and it appears that might have been the only way he could have done so. And so it does concern me when somebody makes an attempt to contact counsel, come in, swoop away the phone, even if it's pursuant to the warrant, and then is unable then to call counsel because there's no alternative way to do it. I mean, that does create, I understand that this was a weird situation, but I've never seen that before.
Sure. So, Judge Strauss, I think a couple of points on that. First, it's not clear from the record whether there was another way to contact counsel. Mr. Duggar was on the scene with 2 companions, one employee, and one possibly friend. They, I believe, at least one of them, it's in the record that he had a cell phone that was not seized by officers as part of the evidence that they collected and transported from the scene. I think that the record just reflects that his cell phone was, they call it like a manual inspection by the officers. So first of all, it's, as a threshold matter, it's not abundantly clear that there was no other phone available that he could use. But even if we assume that that's the case, Mr. Duggar's method of contacting his lawyer, which again, he ultimately availed himself of, was leaving the scene. And once again, the officers told him repeatedly he was free to leave the scene. When they first started their conversation with him, they said, you don't have to talk to us. You don't have to talk to us without a lawyer present. You can, we can do this later once you've had a chance to talk to a lawyer. I mean, I think all of that shows that he was, he had an option to speak to a lawyer, even though obviously the officers had appropriately seized his phone at the outset of their search. I did just want to, on that topic, there are a couple of relevant precedents. I mean, I think in the Mullenbrook case, again, that I discussed a moment ago and that we cited on page 30 of our brief, this court declined to address the defendant's argument that he had made an unambiguous request for counsel during the interview, and you declined to even address that because you determined on the basis of the Griffin factors that he was not in custody during that interrogation. So it's not entirely clear whether there was support for that unambiguous invocation there, but again, the question of unambiguous invocation is a secondary matter after we get past the threshold custodial burden. And, there's also Zecre, where officers directed a suspect not to answer an incoming call, and this court upheld the denial of suppression there after finding that it was not custodial. Also, cell phones were not even widely available when this court decided Griffin, so certainly the availability of a cell phone in someone's pocket or their hand cannot be, kind of a threshold criterion for the attachment of Miranda.
When it comes to the phone, and when it comes to this issue about them seizing the phone and whether or not Josh was in custody, they're using this case, USA versus Griffin, where they're trying to, and that's sort of their benchmark, that there's 6 specific standards that someone has to meet in order for the law enforcement to determine, and for the law to determine if someone is in custody. And those burdens are, they're sort of outlining, like, the biggest issue here is this, can we suppress the statements he made? They have to prove that he was in custody. So you cannot invoke your rights to an attorney until you're actually in custody and arrested. You cannot presumptively invoke your right to an attorney, meaning you assume you might be arrested, to not speak. So you don't get to invoke your right to an attorney until after you're arrested. And so you have to be in custody to make that announcement to authorities. So when it comes to the suppression of statements, their argument is that he was not in custody because he was free to leave at any time. He was not encumbered from leaving. He left on his own. He did not need anyone to move their cars. He did not need to go into the office to get his keys. He left. On top of that, they argued that he was in the car with the officers or the agents and asked them to scratch out that he was in custody, clearly understanding that he was not in custody when he was making those statements. In the audio, when they are interviewing him, he's very clear that he will answer some questions, but he will not answer others. And he will, say, well, I'll have to talk to my attorney about that. So Josh was very clearly understanding, like, there was some things he was willing to say and other parts he was not willing to say. On top of that, he wasn't handcuffed. He was not prohibited from leaving. And once the interview was over, he left. And he left while they were still there. So he was never in custody. And so they're saying, even if we took the phone, even if he asked to call his attorney, it's irrelevant because he was never in custody. That statement is presumptive, and he wasn't in custody. And if you also noticed, the only question he really had was, I'm concerned that he asked for an attorney and he wasn't given that right, or there wasn't another option for him to call his attorney. Theoretically, there were other options. He was free to go, and he did, which he said. There was other people on the lot, 2 of his coworkers, that he could have used their phones. and it wasn't the only means or the only way. And on top of that, when this law was actually put into place, or when the law that they're citing, or the case that they're citing, the Griffin case, that was ruled before there were cell phones. So he's basically saying you can't use that as an excuse to say that he didn't have any other options, because Griffin didn't have any other options because cell phones weren't there during this case. I hope that makes sense. So next he's going to talk about the metadata, and then Justin Gelfand is going to do his rebuttals, and it'll be over.
I know that Mr. Gelfand did not have a chance to address this. I'm happy to answer any questions about the metadata issue or the expert testimony. I did just, very briefly want to say that while I'd be happy to discuss why the district court appropriately exercised its discretion when delimiting this testimony, really the photographic metadata issue is much ado about nothing here, because text messages from Mr. Duggar's iPhone, the accuracy of which has never been challenged. He has never challenged the accuracy of the text messages either in the district court or in his appellate briefing. Those messages independently placed Mr. Duggar at the scene of the crime on dates of offense conduct without reference to any photographic metadata. And just to very briefly go through a couple examples, on May 14th, when the law enforcement program Torrential Downpour detects that Mr. Duggar's IP address was uploading abuse material, that alert happens at 5:42 p.m. At 5:49 p.m., Mr. Duggar's iPhone sent a text message reading, quote, "at my car lot," end quote. On May 15th at 11:15 a.m., Mr. Duggar's iPhone sends a text message reading, quote, "I'm at my car lot now," end quote. 20 minutes later, at 11:35 a.m., child is downloaded on the partition section of Mr. Duggar's computer. And later that day, at 5:08 p.m., Mr. Duggar's iPhone sends a text message reading, quote, "I'm here at the car lot, will be here till around 6 or so," end quote. 14 minutes later, at 5:22 p.m., is downloaded on the partition. So even if you were to set aside all of the photographic metadata in its entirety, uncontroverted evidence, specifically Mr. Duggar's own words in his text messages, places him at the car lot in close temporal proximity to the criminal conduct here. Unless the court has further questions, I'll rest on our brief and respectfully request that you affirm the judgment below.
Josh's attorney's arguments about the metadata has to come down to them saying that James Futrell did not share his methods and wasn't they didn't say that he was an expert in how to figure out metadata, which is, again, another red herring. And Joshua Handel for the U.S. basically says that even if you throw out those ones that were about the metadata, there's actual text messages from his phone that literally have him at the car lot when the content is being downloaded. And he provides multiple examples of literal text messages that he says Josh Duggar has never refuted that these are his messages, that he sent this. At no place in time has he ever said that these statements were not made by him. Each time it's within a very short window that he sends a text message, and then content is being either uploaded or downloaded onto his computer. And that's when the group that was monitoring this peer-to-peer network pinged him and found that he was doing these downloads and uploads, and they were able to extract the content from him. So they're saying even if you have to throw out those ones, there's all these text messages that he sent, and he's never refuted that. And it'll be interesting because Justin's arguments will be like, well, we don't know what the jury used in order to actually determine his guilt. Regardless, the metadata, as he said, it's a non-issue. It's a red herring. It's much to do about nothing. It's making a big deal out of something for the sake of an appeal. That was his thing, his issue. And if you noticed, he wasn't interrupted. No questions were asked by the judges. So again, this specific argument, I think, is solid.
Thank you, Your Honor. May it please the court. In response to the court's question, opposing counsel said, quote, "There's no evidence that Mr. Williams was present at the car lot on May 13th, end quote. In fact, the government never presented any evidence, credible or otherwise, that Mr. Williams was anywhere or wasn't anywhere on the dates at issue, and the government had every opportunity to do so. The government responded to the questions about the court's limitations by suggesting that the court essentially imposed very limited limitations. That really is belied by the record itself. What the court expressly said after applying a test that the Supreme Court said was unconstitutional in the first place is that if he says he wasn't there, you can't talk about what happened. That's a direct quote from the transcript. But Judge Strauss's question really strikes at the heart of this issue, and I think it's critical that everyone understands this. What the judge did, and I mean no disrespect to Judge Brooks, but what the trial court did is the day before in that in-chambers on-the-record conference that we cite abundantly, is he stated the wrong principle and expressly said that he was, in fact, going to consider the strength of the government's case. Then the very next day, when we're at sidebar and this comes up, the court expressly cites the portion of the Holmes case that does that. There was no ambiguity. The court said, I'm going to look at the strength of the government's case in evaluating this, and then the court, in the very moment, does look at the strength of the government's case. He actually expressly says so. And the reason why that's so important is that that's an error of law, and it's an error of law of a constitutional magnitude, because what it did is it effectively imposed such concrete limitations on what Mr. Duggar could do if
so
he
the court's
called.
correction of the misstatement you don't think was effective?
Your Honor, the court's correction of the misstatement, so to speak, happened in an order denying our motion for new trial, raising this issue, and the court in no way spoke to the what happened in chambers the day before. And that sheds significant light on the rationale or the test that the court was applying. So no, I don't believe that that solves the issue. The reason that we have contemporaneous transcripts is because, especially in this instance where the court is articulating, here's the test I'm applying, here's the standard I'm applying, that would be an impeccable record if the test was a constitutional test, if the test was a correct test as a matter of law in understanding what the court was doing. And to the court's credit, the court was articulating what the court was doing. The fatal problem with that for purposes of anything other than reversing and granting a new trial is that's the very analysis, the strength of the government's case, that the U.S. Supreme Court in Holmes determined was unconstitutional. The fourth real quick just point of clarification is that the colleague's cell phone that was briefly mentioned with respect to the individual of Mr. Duggar was being, and I don't remember the exact phrase used, but essentially manually triage searched by law enforcement. To say the least, that does not make it available for Mr. Duggar to contact his lawyer. There was nothing stopping the agent from saying, I am seizing your phone, but use my phone or use a law enforcement phone to contact your attorney. The agent didn't want Mr. Duggar to have the opportunity to speak with counsel, even though he physically tried to do so. Now, finally, it is well-settled law that an expert can critique the methodology used by other experts. And it appears at oral argument that what the government is essentially saying is, this is a whole lot about nothing. Essentially what the government is saying is this is harmless error, and the court should look to these text messages. That's not sufficient based on the fact that this was a general verdict that was delivered by the jury. In other words, we don't know which particular date or time the jury used to determine whether Mr. Duggar was proven guilty beyond a reasonable doubt as to the count of conviction. And so the reason this EXIF metadata is so critical is that this was what we call in our brief the house of cards on which the government's case was built. In other words, attempting to place Mr. Duggar at or near the car lot at specific dates and times. But that house of cards was delivered by Mr. Fautrell in a way that should have been subject to critique by Ms. Bush. For all of these reasons, we ask that this court reverse this case and grant a new trial, a fair trial, a constitutional trial. Thank you.
Thank you, Mr. Gelfand. Thank you also, Mr. Handel. The court appreciates both counsel's participation in argument before the court this morning. We'll take the case under advisement.
Justin Gelfand uses language that's very polarizing, and he wants to elicit emotion. But eliciting emotion doesn't negate the facts in the case, and so he can use all of these terms like egregious and unconstitutional and violation, but that doesn't mean it actually is true. In fact, they, pushed back on him multiple times saying the court corrected this error, and he's like, well, no, it was in a totally different spot and it's irrelevant. Is it? The issue with Caleb Williams as well, discussing about not being able to call him, it's multiple issues at hand. One was a 403, which is basically whether or not evidence can be introduced or not introduced, and if this would confuse the jury. And there's a lot of speculation here, an implication that the reason why they wanted to call Caleb was specifically because of his offenses. But those offenses were not relevant to this case. And again, he was not there. He said that the prosecutors in this case, Joshua Handel, didn't provide any evidence. He didn't need to. He wasn't asked to. He had the evidence that he showed to the court in chambers. He didn't have, and he can give this court the evidence that they need for this. They didn't ask for it. He provided all of that evidence. The prosecutors, the U.S. attorneys, provided that in chambers. Justin doesn't want to acknowledge the fact that they have all of this evidence that proves he wasn't there. And instead, he wants to blur the lines and make you think that there's something bigger here that happened, some sort of conspiracy that prevented him from calling Caleb. The facts are Caleb wasn't there. They had the proof that he wasn't there, and the only reason that they wanted to call him was because of that unrelated offense. So bringing him onto the stand when you know he's not there, you can't tie him to any of these crimes, again, would only confuse the jury. So the foundation wasn't there. And he tries to say, I'm not dragging the judge in the district court, Judge Brooks, but I'm going to drag him. At the very end, he also talks about the metadata. Again, an issue of much to do about nothing. And he calls it an error. The court never ruled that the metadata issue was an error. In fact, to the contrary, they said it wasn't an error, but he claims that they're implying it was an error. Just more language by Gelfand to try to elicit emotion and confuse. The thing is that he doesn't have a jury here that he's trying to confuse. It's 3 judges that deal with these kinds of appeals on a daily basis, and I just don't think he has enough to overturn Josh's conviction or grant him a new trial. Taken under advisement means they will take everything into consideration, all of the appeals briefs, all of the information from the trial, and they'll issue an appeal brief with their decision at a later date. So right now, my opinion is this did not go well for Josh, and I do not expect him to get another trial because precedents in this court do not meet Josh's Josh's arguments do not meet the precedences of this court. Every single argument that he had, there was a precedent in the court that was to the contrary. So Josh was not in custody. The issue with the metadata is a non-issue. And when it comes to Caleb Williams, the only reason he wanted to call him was because of his conviction, which was irrelevant to this case, and he wasn't there. So that's what I have for you. My opinion is it didn't go well. There was some things that the judges seem to have questions about, but I think at the end of the day, it will come out in a wash because no side will ever be totally perfect. And I think Josh's attorneys will have a few minor wins, but I don't think it'll be enough to get him a new trial. Tell me what your thoughts are in the comments below. Bye, guys.